Can I move on to the next question from Dean Russell?
Thank you, Chair, and thank you, Lord Chancellor, as always, for coming onto the committee and for the work that you do generally. As you all know, the Human Rights Act requires courts to take into account judgments of the European Court of Human Rights relevant to the proceedings before them, and they're not bound to those judgments. And some of the witnesses and the reports that were put together, or our report in particular, found that if our courts couldn't take the European Court of Human Rights cases into account, there'd be more adverse findings against us by them, and in which case the European Courts for Human Rights wouldn't benefit from the views of our judiciary. So such changes to the Act, the Human Rights Act, could result in us losing rather than gaining control. And I just wanted to get your view on whether you agree with that statement, whether you disagree, and what your thoughts are in general on that point.
Well, I think, Mr. Russell, I think you hit upon one of the points that is actually raised in the terms of reference, which talk about the dialogue, if you like, between Strasbourg and our own domestic courts. I've always regarded that as a very important part of the work within this area, and I have always encouraged it. I've encouraged an offline dialogue between judges of the different courts. I think that's a very healthy thing to do, and we've got some notable exponents of that. I can think of Lady Arden, for example, who did a lot of work when she was a Lady Justice of the Appeal, and there are many others within the judiciary who work very hard on those international relations and dialogues. I think if let's see what the review comes up with. I can't prejudge what it might say, but if there was a sort of a wholesale move to sort of disregard or deliberately ignore the decisions, the judgments of Strasbourg, then clearly there would be that would represent a potential breakdown in that dialogue. And I don't know what the review's going to say, but I would be surprised if there was a move, in that sort of absolutist direction. I rather suspect that whatever the outcome of the review and any subsequent proposals might be, that element of dialogue, that element of understanding will still be very much part, not just informally, but also formally when it comes to decisions that clearly engage rights that the convention and which need to be addressed by our domestic courts. So I'm pretty confident that interplay will continue.
Thank you.